Yes, yes.
My lord, I beg to mention item 18 and 19 of hearing list. I have taken the consent made instead of 19 of this.
19th of this month,
Yes,
18th
okay.
and 19th. Learned Counsel Mr. A. Jimomi,
Yes.
with the consent of the other side, has prayed for adjournment, list the matter on 19th
9.
August.
And there is an interim.
Hmm?
There's an interim.
Okay, okay. Interim order shall remain in force till then.
Madam.
This person,
Hmm.
is allowed to mention hearing item 13 on behalf of Peace Roy, the counsel for the petitioner. On his instruction, I put a matter come up on 7 Thursday.
All right.
Motion.
Learned Counsel Mr.
I'm Pakin Sabu, my lord.
Huh?
Pakin Rit Sabu.
Okay. Pakin Richapo. Richapo. On behalf of Learned Counsel Mr. P. Suryan,
Yes, ma'am.
with the consent of the other side, has prayed for adjournment, list the matter on
On 7 Thursday.
on 7th. Okay.
And my lord, please allow me to mention another item from the supplementary process item to speak. The Pahar matter. And despite our best effort, we could not obtain the case law. So with the consent of the opposite party, I pray the matter comes up on Thursday day after tomorrow.
Okay. Learned Counsel Mr. Pakin Richapo, on behalf of Learned Counsel Mr. S. Say,
Yes,
with the consent of the other side, has prayed for adjournment, list the matter on Thursday. Thursday is 7th.
yes, madam.
Okay.
Lordship, as part of matter.
Or as part of matter. Oh.
Get your.
Very grateful.
So.
Mm.
Lordship, I recommend they had a working.
Mm.
Recommend that you come out with this.
After 3 weeks. Okay. Learned Counsel, Mr. M. Jemu. Your name is not in the cause list, no? So and so, on behalf of Learned Counsel, Mr. Muaz Amir, with the consent of the other side, has prayed for adjournment, list the matter after 3 weeks.
Lordship,
Mm.
Lordship, I beg to mention item number 6 and
Mm.
7
Mm.
on behalf of S. Chang. Kindly grant 3 weeks time to file affidavit.
Item number 6 and 7.
Lordship, 6 and 7.
Okay. Learned Counsel, Miss
Miss Pichano on behalf of S. Chang.
Pichano, on behalf of Learned Government Advocate,
Lordship,
Miss H.
S. Chang.
Chang, with the consent of the other side, has prayed for adjournment. List,
Lordship, I have no objection.
list the matter on
After 3 weeks.
after
Lordship.
3 weeks. Okay.
Lordship, similar prayer with item number 8 and 9 on behalf of S. Chang.
Similar. 8 and 9, similar order. You have any objection? No. Okay.
Lordship, I also like to beg to mention item number 10, Lordship.
Mm.
Here the department is the process of verification. So if I may be granted another 2 weeks time.
Mm. Once more, your name, Learned Counsel, Miss
Pichano.
Pichano, with the consent of the other side,
Lordship.
has prayed for adjournment. List the matter after 2 weeks.
Lordship.
Okay.
Lordship, item number 11 on
Mm.
behalf of M. Longobar. Kindly grant 2 weeks time to file affidavit, Lordship.
Learned Counsel, Miss Pichano.
Lordship,
Learned Counsel, Miss Pichano,
Lordship.
on behalf of Learned Government Advocate, Mr.
M. Longobar. Lordship.
M. Longowar, with the consent of this other side, you have any objection? Has prayed for adjournment, list the matter after 3 weeks.
Lordship.
Interim order shall remain in force till the next date of listing. Okay.
Lordship,
Mm.
from the hearing list, item number 12 on behalf of Tipa. Lordship, they can list this matter after 1 week.
Any objection?
Recommended we fix Thursday, Lordship, on 14th.
On
14th, Lordship.
14th.
Yes, Lordship.
14th August. Learned Counsel, Miss Pichano, on behalf of Learned Government Advocate,
Tipa,
Mr.
Your Lordship.
Mr. Thipa, with the consent of the other side, has prayed for adjournment. List the matter on 14th. Ki kole? 14th.
Lordship.
14th August. 14th August. Item number 14. Okay.
I oblige, Lordship.
Mhm.
For admission, item number 1.
My pleasure, Lordship.
Mm.
Lordship, kindly grant me 3 weeks time to file affidavit in reply, filed by the Commissioner. No objection,
Learned Counsel, Miss Pichano,
Lordship.
on behalf of Learned Government Advocate on
Lordship, S. Mary,
Miss S. Mary,
Lordship.
with the consent of the other side, has prayed for time to file affidavit.
Affidavit in reply, Lordship.
Affidavit in reply. List the matter after 3 weeks.
Lordship.
Please include with the consent of the other side.
I oblige, Lordship.
Item number 2.
May I please you, Lordship?
Mm.
The matter is with regard to a compassionate appointment.
Mm.
I'm appearing for respondent number 3, 4, and 5, Lordship.
Mm.
I've received a instruction,
Mm.
so I may be allowed. I'll be filing my affidavit this week, Lordship. The matter can be listed next week, Lordship.
Okay.
Lordship.
All right.
If it can be come up on 12th, Lordship.
12th.
Yes, Lordship, Tuesday.
12th.
Lordship, Lordship.
Learned Counsel, Miss
Apila Santam, Lordship.
Apila Santam, for respondent number 3 and 4.
3, 4, and 5, Lordship.
3, 4, and 5 has submitted for time to file instruction to file affidavit, as she has already received instructions. Learned Counsel, Miss
Atsla Gibbs.
Atsula Kips,
Yes.
R. Atsula Kips, is present on behalf of the petitioner. List the matter on 12th
Lordship.
12th August.
Lordship. Oblige, Lordship.
Mm.
Item number 3.
Mm.
Hey, please, Lord.
Yes, yes.
The petitioner,
Mm.
the state respondent as well as private respondent were filed.
Mm.
Though the matter has been listed for 9 times, so far they have been asking adjournment after adjournment.
And
So
today they are not there.
They're not there. So therefore, my humble prayer, if this matter may be, if they're not interested to file after 9 times listing, this is 2024 matter, my. If this matter may be listed for admission hearing, today I cannot insist for hearing because in their absence I should not. But if this matter can be listed for hearing, admission hearing, and within that particular period, if they can file a fee, fine. Otherwise, this cannot be kept pending for such a long time without attending to the case. Even notice on private respondent 5 also completed.
Mm.
Yes, long before. Unless the matter is fixed for admission hearing,
Mm.
they will not come forward. If there is that, then they will, I believe they will come forward.
Maybe. Learned Counsel, Mr.
Joe, my lord.
A. Joe.
Joe.
Learned Counsel, Mr. A. Joe is present and has submitted that several adjournments have been taken by the respondents, but no affidavit has
No
been,
affidavit, so far no affidavit.
but no affidavit has been filed by the respondent so far.
Lordship, can you grant 3 weeks time to file?
No,
On-
I have a serious objection. Because this is 2024 and they have asked adjournment on all the occasions, my lord. So at least let them file affidavit.
And Lordship,
So at least-
sometime we be granted, Lordship.
At least give them 1 week because I really feel embarrassed.
1 week, 1 week.
Yeah, 1 week. At least. I
You are
feel
government advocate, no?
Lordship, on behalf of Mr. Additional Entry, Lordship.
Okay, but you are government advocate.
Lordship, Lordship.
Okay. Learned Counsel, Miss Bichano.
Lordship.
Learned Government Advocate. You write down Learned Government Advocate, Miss Bichano, on behalf of AAG, Learned AAG, Miss V. Sufri,
Lordship.
has prayed for 3 weeks' time to file affidavit, to which the Learned Counsel for the petitioner has raised serious objection, stating that as far as 9 adjournments have been procured by the respondents, list this matter after 3 weeks for filing affidavit.
My lord, 3 weeks is little long.
Oh, sorry.
1 week.
1 week. I said 1 week and now I'm dictating 3 weeks.
At least I want to do just to my client.
Yes, of course.
My
To
lord.
1 week. For
Item
filing
number,
affidavit and for admission.
My
Item-
lord.
item number 4.
My lord, there is an interim.
Interim order shall remain in force till the next date of listing.
Much-
Last one, item number
much-
3.
much.
Yes, Your Lordship. Meetings are completed, Your Lordship.
Readings are complete.
The matter may come up for admission hearing on August 11.
Lordship, Lordship.
Learned Counsel, Miss
And solo.
N.
Solo.
So and so is N Solo. N Solo is present for the petitioners, and Learned Government Advocate Miss Bichano is present for the respondents. As pleadings are complete, list this matter for admission hearing.
I approach.
Your Lordship, on August 11.
Okay, on August 11. 11 August? Okay, all right.
Lordship.
Item number 5.
May it please your lordship.
Yes.
By way of this present date petition, my lord, I am challenging the my lord from DRC 01 as well as from DRC 07. Before that, I would like to take your lordship to the provisions of the law, my lord, section 74, my lord. of the CGST Act, my lord.
You have the act, CGST Act.
Your lordship. Okay, so in this matter, I have received the instructions, but I yet to file my affidavit in opposition. So I think state may be fixed, your honor.
Yes, what do you have to say? He's yet to file the affidavit in opposition. Will,
Lordship, he may file, there is no objection.
will grant a fixed date.
A fixed
My
date.
lord,
Okay.
my lord.
Okay. Your name, Learned Counsel Minister.
R.S. Mishra, my lord.
R.S. Minister is present for the petitioners.
Yes.
Petitioners, my lord.
Your name
April 11.
and Learned Counsel Miss So and so is present for the petitioner. Learned Counsel Mr. Government Advocate.
Standing counsel,
Standing Counsel for you,
the CBIC.
CBI. Learned
CBIC. PIC.
CBIC. Learned Standing Counsel for CBIC, Mr.
ZCOL.
Z. Kolo
Yes.
is present and has submitted for 3 weeks' time
Yes.
to file
The affidavit number.
the affidavit in opposition, list the matter on. Yes, you come to an agreement on a date,
Can it be on 22nd of August?
22nd of August.
Okay.
Yeah, 22nd of
lord.
August. List the matter on
But there
22nd
is
of August.
There's an interim order, my lord.
Interim order shall remain in force till then.
Much obliged.
Much obliged, your lordship.
For hearing, item number 15.
Thank you, Your Lordship. Lordship, this matter pertains to non-furnishing of information sought under the RTI Act. Lordship, by Annexure 1, page 23. So through this RTI application, I sought for 3 information. One is decision taken during consultative meeting that was furnished to us, Lordship. Then number 2 and 3 were not furnished to us. Number 2 is committee report with all relevant documents and cadastral survey as directed by office notification dated so and so. And number 3 is meeting convened and meeting minutes with attendance sheet of 27 September 2021, video recording of meeting proceedings of the same day, and decision of the meeting held on the same date. So number 2 and 3 were not furnished to us. So accordingly, we filed for an appeal to the first appellate authority by Annexure 3, page 28. So here also we received the same reply from the first appellate authority, stating that they have furnished the first information sought, but then the second and the third one is their reply is at page 32, Annexure 4.
Page 32.
Yes, that is the reply of the first appellate authority.
Okay.
So here they have stated that the first appellate authority
Annexure 5. Oh no,
Annexure 4.
Annexure 4. Okay.
Sir, with reference to your appeal letter addressed to the first appellate authority received by the department dated 16th December 2022, I am directed to convey that the government stands by its earlier reply by letter number such and such dated 21st November 2023. That is the reply by the PIO. So in that reply, they have not furnished number 2 and 3. So accordingly, Lordship, we preferred an appeal before the State Information Commission and seeking for number 2 and 3, information number 2 and 3. So our appeal is at page 34, annexure 5. That is our appeal to the Chief Information Commission. And accordingly, by annexure 6, we were given notice for hearing before the State Information Commissioner. Annexure 6, page 36. And annexure 7, page 38. And annexure 6, page 36 is the notice for hearing. Then annexure 7, page 38. That is the record of the proceedings and the decision taken before, taken by the State Information Commissioner. So Lordship, so the hearing was held on 19/4/2023, and the decision was given on 28/4/2023, Lordship. So the relevant portion is at page 40. Page 40, Lordship. This is regarding query number 2. Lordship, in the last paragraph of page 40. Regarding query number 2, on being asked by the commission whether the committee has submitted its report as decided in the consultation meeting held on 4/3/2021, Shri Akam Jamir, advocate and legal consultant for the APC and SAA, informed that the final report of the committee on land issue at OTAO Office Complex Kohima was submitted to the Agriculture Department in April 2021. So Lordship, this makes it clear that it is an admitted fact that there is a committee report, and the date is also the month is also given here, which is April 2021. So the committee report is on April 2021. So Lordship, there is no so Lordship, my submission is that this is an admitted fact that there exists the information that I have sought for in my first RTI application, Lordship. And Lordship, the next page, that is 41, regarding query number 3. Shri I. Inti Longta, advocate and legal consultant for the applicant, now appellant Shri Bantan Muri, stated that the meeting was attended by 1, 2, 3, 4, 5. Lordship, these are all officials of the department. However, translating to the WhatsApp message, Shri Zakabowi Gopaka, Deputy Secretary and PIO Agriculture Department, has stated that it was on the request of the applicant that the meeting was called on 27/9/2021 at 12 noon, and hence there was no official correspondence by the department in calling the meeting, and no attendance and no videography were taken. So Lordship, regarding this, it is stated that there were 4 officials who attended this meeting on 27 September 2021. So Lordship, there's an office memorandum at annexure 8, page 43. Annexure 8, page 43.
Yes.
Lordship, the third paragraph, starting with 34. 34, record of verbal discussions, orders, and instructions. All points emerging from discussions between 2 or more officers and the conclusions reached should be recorded on the file by the officers authorizing action, and where necessary, the circumstances leading to such orders, instructions. This should be recorded in the file, and in important matters should be confirmed. So Lordship, when there has been a meeting held in attendance of 2 IAS officers and 2 other officers from the department, it makes no sense that there is no record of the said meeting, Lordship. So Lordship, that is page 38 is the final decision, and Lordship, moving forward,
Page?
page 38, annexure 7, that is the final decision of the State Information Commission. However, even after this decision, Lordship, Annexure 9, page 44, the Department of Agriculture wrote, that is the PIO of PIO and the Deputy Secretary to the Agriculture Department wrote to the Chief Information Commissioner on 8 May 2023. Subject request for modification of Nagaland Information Commission's decision. So Lordship, the relevant paragraph is the second last paragraph and the last paragraph, Annexure 9, page 44. Here the PIO is requesting the CIC that the committee's report being confidential in nature for the department, the department is of the opinion that it may hamper the department and the government at large, and it will be very premature to furnish the committee's report to the appellant before a decision on the matter is taken by the government. Therefore, in view of the aforesaid facts and circumstances, I humbly request your authority kindly modify the paragraph 1 of the decision dated 28 April 2023 in order to let the government take action on the committee's report first, upon which the report of the committee will be submitted within 3 months' time. So, Lordship, here they are requesting for extension of time for furnishing the information, which the CIC has given a direction that it should be furnished within 15 days. So, this was the request made by the department. Here, Lordship, no copy was served to us. We are the appellant in the before the SIC, but there was no copy that was served to us. And according to this request, the SIC had modified the decision by Annexure 10, page 45. Lordship, may I read the whole decision? This is impugned, Lordship.
You see, that final decision at page 38. So according to the final decision, there are some secrets which should not be out. Then thereafter, they decided that they will furnish the committee report.
Yes, Lordship.
They sought for extension of time.
The SIC had said that it is not covered by Section 8 of the RTA Act. So accordingly, they have stated that it should be furnished to us within 15 days, and the committee should.
So it was finally decided that it is not under Section 8 of the RTI Act,
Yes.
so copies could be furnished.
Yes, that was.
So that was the final decision, or?
Yes, Lordship.
Okay.
Yes, Lordship. So Lordship, the impugned
Yes.
modification at page 45, and it says. Subject mod, this is by the Nagaland Information Commissioner, dated 22nd May 2023. Subject modification of the decision of the Nagaland Information Commission. Whereas after the hearing of the second appeal dated 14/2/2023 on 19/4/2023 at 11 a.m. in presence of both the parties, the commission had passed its decision by even number dated 28/4/2023, which is produced as below. A copy of the committee report on the land of the old DO office complex, Roka, which was to be submitted to the Agriculture Department in April 2021, shall be furnished to the applicant, now appellant, and with a copy of the commission within 15 days from the date of receipt of this decision. 2. Though the committee had given its recommendations, the department has been taking a long time to complete action on the recommendations. Hence, as requested for more time, the department shall complete acting on the recommendations of the committee within 3 months, which might help in resolving the long pending issues. And whereas on 19/5/2023, the commission had filed letters such and such dated 8/5/2023, received from so and so Deputy Secretary and PIO Agriculture Department, Nagaland, Kohima, requested for modification of point number 1 of the above decision on the commission dated 28/4/2023, stating that the committee report being confidential in nature for the department. Department is of the opinion that it may hamper the department and the government at large, and it will be very premature to furnish the committee's report to the appellant before a decision on the matter is taken by the government. Therefore, request to modify paragraph 1 of the decision dated such and such in order to let the government take action on the committee's report first, upon which the report of the committee will be submitted within 3 months. And whereas the commission had, after examination of the above request for modification of the decision, accepted the above request that instead of furnishing the committee report to the applicant now appellant within 15 days from the date of receipt of the decision, the committee report shall now be furnished only after the government decides on the recommendations of the committee, in which 3 months' time was given to the department as decided at decision point number 2 of the commission's decision dated 28/4/2023. Now, therefore, the commission decided that the committee report shall be furnished to the applicant now appellant only after the government takes action on the recommendations of the committee, for which 3 months' time was allowed as requested. This copy was given to us, Lordship. However, we were not heard on the request that was made to the SIC by the PIO. So, Lordship, it is my submission that this is a total disregard of the principles of natural justice, where the decision to give or not to give information to me was decided in my absence, Lordship. And
Okay.
also, Lordship, this action of the SIC to modify their decision, which is final and binding, is totally against the powers given by the statute. And Lordship, where it is a known fact that the SIC is a statutory body, and they cannot act beyond the powers given by the statute itself, where the statute has not given any powers of review or modification to the SIC. This action is totally ultra-vires the powers that is provided by the statute, Lordship. That is one of my submissions. So, Lordship, according to this modification that was given by the SIC, this impugned meeting minutes
Okay.
So according to the decision, the government had held a meeting, and accordingly, this meeting minutes, page 27, annexure 1. This is also impugned, Lordship. So this, according to that meeting, this meeting minutes was published. So the relevant portion, Lordship, is on the third paragraph. Page 47, annexure 11.
Page 47.
Annexure 11,
Okay.
third paragraph. All the department concerned, this is the minutes of the meeting held in the presence of, held by the chief secretary in the presence.
This
of-
is the impugned.
Yes.
You have impugned this also.
Yes.
Annex 11.
Yes, ma'am. So annexure 10 and 11 are impugned.
Okay.
The department concerned were allowed to present their issues, and after taking into consideration the inputs, suggestions, recommendations on the matter given by the members present, the following decisions were made: to set aside the earlier committee's report and set up a new committee on land issues at old DAO office area Woka to thoroughly look into the matter. The committee members will be the same as those committee members constituted before, retired members to be replaced. In view of the severity of the issue, the committee so constituted shall be classified as confidential, and all matters / files in this regard shall also be marked confidential. The committee so constituted will submit its report within 3 months from the date of setting up of the new committee. 2. The matter of land issues at ODAO office area Woka shall be placed before the advisor minister in charge, along with the report of the above said committee. 3. To write to the Chief Information Commissioner of Land Information Commission, stating that the government is in consideration of the case and accordingly it has set up a new committee. So that is the decision made in this meeting, dated 30th June 2023.
Okay.
And accordingly, this was communicated to us after they have set aside their earlier committee report.
Okay.
So, Lordship,
What is your prayer?
Lordship, my prayer is that annexure 10, annexure 10 be set aside for the reason that the SIC has acted beyond its statutory limits. And also Annexure 11 we set aside for the reason that this decision was taken purely to nullify the decision of the NIC dated 28 April 2023, Lordship. So Lordship, and accordingly furnish the information which was decided by the NIC in their final decision.
Okay.
Lordship, obliged.
May I please, Your Ladyship? I'm for respondent number 1, 3, 4, and 5 for the state. Your Ladyship, here the first committee report has been cancelled due to lack of documentary evidence. So the government has a power to constitute a new committee to look into the matter. And so the second committee has been constituted. They are on the verge of completion. And as per the findings of the NIC, it has to be furnished to the petitioner only after the approval of the government. That is very clear from the findings in Lordship. Your Ladyship may kindly come to page 46, the findings of the NIC.
Yes.
Your Ladyship have it.
Yes.
Now, therefore,
It is in your reply,
Your Lord, Your
page
Ladyship,
46 in your
46 of the repetition.
read petition. Okay.
Yes, Your Ladyship.
Okay.
Now, therefore, the commission decided that the committee report shall be furnished to the applicant, now appellant, only after the government take action on the recommendations of the committee, for which 3 months' time was allowed as requested. So this sentence means that only after the government approves it, it will be furnished to the petitioner within 3 months' time. And when the first committee report is nullified, where is the question of furnishing the document? Your Ladyship will see the reply given to the petitioner. RTI reply at page 8 of my affidavit in opposition. All the prayer of the petitioner has been culminated into this reply. Your Ladyship, may kindly see page 8 of my affidavit in opposition. May I read, Your Ladyship? With reference to your letter number dated 9th of November 2022, I am directed to furnish here with the reply to the information sought under the RTI Act. Reply regarding query number 1. Decision taken during the consultative meeting on the land issue at all DA or office worker.
Page 8 or para?
Page 8 of my affidavit in opposition. This is a reply to the petitioner.
Affidavit in opposition. Okay.
Yes.
No.
Affidavit.
I'm taking up some other affidavit.
Affidavit in
Respondent number
opposition on
2.
behalf of respondent 1, 3, 4, and 5.
Yes, yes. Now I got it. Page 8, no?
Yes, Your Ladyship.
Yes.
So, to the petition, that is Danton Murray. Subject furnishing of RTI reply. Sir, with reference to your letter number dated 9th of November 2022, I am directed to furnish here with the reply to the information sought under the RTI Act. Reply regarding query number 1. Decision taken during the consultative meeting on the land issue at all DAO office worker held on 4th of March 2021 under the chairmanship of the APC is enclosed as at Annexure 1. Reply regarding query number 2. Committee report with all relevant documents and cadastral survey cannot be disclosed by the government under Section 8 of the RTI Act 2005. Regarding your query number 3, meeting minutes with attendance sheet, the office does not keep records of any informal meetings with any individual, society, organization, etc. B, video recording of the meeting. The office does not keep or take video recordings of meeting proceedings. The APC office chamber has CCTV cameras installed in the office entrance and in the conference hall for security purposes only. Decision of the meeting. No official decisions were made. A request confirmation to meet the APC through WhatsApp message, text message / telephonic conversation, etc. cannot be treated or considered or claimed as a meeting convened by the Agriculture Production Commissioner, Nagaland. This is for your kind information. So this itself is very clear that there is no official meeting. And in fact, why the first committee report has been set aside is, as I said, due to lack of documentary evidence. And so since the state is empowered, there is a provision which I've annexed it in my page 9. As secretary may, your ladyship, point 29, page 9, point 29.
Okay.
A secretary may ask to see the papers in any department other than the finance department and departments under the chief secretary, if such papers are required for the disposal of a case in his department, provided that for the departments under the chief secretary, the latter may consider the request of the secretary and may allow the papers to be sent by the secretary, provided further that if a department feels that a case should not be shown to other departments, the matter will be placed before the chief secretary to orders. Such requests shall be dealt with under the orders of the minister. Coming to point 6, next page, page 10.6. All papers relating to any matter that may have to be submitted to the cabinet or to the chief minister shall be submitted through the chief secretary, who will then forward the same with his comments, if any. The chief secretary also may, on the orders of the chief minister or of any minister or of his own motion, ask to see paper relating to any case in any department, and any such request by him shall be complied with by the secretary of the department concerned. The chief secretary may, after examination of any case requisitioned by him on his motion or on the orders of any minister, submit it for orders of the ministers in charge. Point 31. If a question arises as to the department to which a case properly belongs, the matter shall be referred to the decisions of the chief secretary, who will, if necessary, obtain the orders of the chief minister. So in exercise of this power, your ladyship, a committee has been set up. Page 12, the second committee has been set up to look into the matter. Page 12. May I read, your ladyship? In superstition of the notification dated 4 August 2023, and in pursuant to the decision taken during the meeting on land issues at all DAO office area, Wokha, held on 23/6/2023, under the chairmanship of the Chief Secretary Nagaland, a new committee is hereby constituted with the following composition. So. The committee will examine all relevant documents, government notification, OMs, and submit the report by 30th November 2023. The committee is classified as confidential, and hence all matters or files in this regard shall be kept or marked confidential. So, your ladyship, the new committee, they are on the verge of completing. They are on the verge of completing the to submit their report. So only after they submit the report and only after the government approves the matter, it can be furnished to the petitioner. So the question of furnishing the documents at this point of time doesn't arise. And your ladyship, so this.
Are you on the verge of submitting the report?
That is what I have been informed by the committee.
Okay.
Yes.
Can you affirm since till when this report will be submitted?
That I have.
Thereafter, we can proceed then. Can you obtain instructions?
No, the only.
Will you wait or you want the order?
Your ladyship, the only issue here is whether the committee, the first committee report, whether we are supposed to furnish the first committee report, and that I have given my submission. It's up to your ladyship to decide as to whether that is.
I have to decide. Okay.
When there is no documentary evidence.
According to this, this is the second committee report,
yes,
which is about to be submitted.
Yes, yes.
Okay.
Yes, the first committee report has been nullified. So the second committee has been constituted as per the provision laid down.
So will you wait or should I pass an order? Will you wait for the confirmation whether this report has been submitted?
Lordship, that can be done, but at the same time, Lordship,
Okay.
the issue involved is also the first committee report. It is an admitted fact that.
But according to them, that it has been nullified and so.
Yes. But that was the decision after the.
After
final
your,
decision of the
after
SC.
your application for
Yeah.
the,
So,
under the RTI Act.
yes. That is final and binding, and only after that was this decision made by the government lordship. So that is also.
No, we are, the committee is here to submit. How can the government take this decision now?
Lordship, we are not asking for taking decision on the first committee report. We just want the first committee report, which we have sought through our RTI application.
RTI reply is clear and now to your ladyship. So that's,
After that.
and I see regarding the findings, they will answer.
Okay,
Yes.
yes. You are for respondent number 2. Respondent number 2 is
Nagaland Information Commission.
Nagaland?
Information Commission.
Okay, okay. That is the main office. You are for the government
Yes.
and you are for the commissioner.
Commission.
Who is the main appellate body?
Yes.
Okay, what do you want to say?
Roshni, can you come to page number 34 in your petition?
Yes, page number 34 of the.
34. Should the present petitioner agreed by the decision passed by the first appellate authority of the Agriculture Department? Should the approach the commission by submitting this application? Should this application was submitted on 14 to 2023?
14?
14 to the 2023.
Yes.
Accordingly, the commission issued a notice, which is at page number 36.
Okay.
The notice was issued on 30th March 2023. That is at page number 36.
Yes.
So, accordingly, as publishing the notice, the parties were present before the commission for hearing on 28 April 2023. And the decision passed by the commission is at page number 38. In order to highlight the background of the case, may I take your lordship to page number 40.
Okay.
You will find the observation and findings of the commission.
Yes.
Short paragraph only. So I mean, a lot to read.
Findings, yes.
Yeah, observation and findings. Here, the entire text is highlighted here.
Observations and findings, yes. She has read out.
So that. So only the decision of the commission. May come to page number 41. In the bottom. After considering the appeal filed by the lead petitioner who was the appellant before the commission, the commission has passed two directions. The first direction was to furnish the committee report to the applicant within a period of 15 days.
Yes.
And the second decision was, it was the case before the commission that of the department that the committee report is pending for approval of the state government. So unless the state government approve the documents, it cannot be treated as an official documents. So the second decision was passed by the commission after hearing the argument of both the sides. Though just the point number 2. Though the committee had given its recommendation, the department had been taking a long time to complete action on the recommendation. Hence, as requested for more time, the department shall complete acting on the recommendation of the committee within 3 months. We kindly note the period here, the period 3 months. The commission has given the department a period of 3 months to approve the recommendation of the committee. Hereafter, the department they can before they approach the commission by letter dated 8 May 2023. That is at page number 44. Seeking for modification of the first direction. As per the first direction, the department was directed to furnish the information within a period of 15 days. So the department sought for modification of this order. Worship, it is an admitted fact as alleged by the writ petitioner. Worship, the commission has also made a mistake. The commission has not issued a notice to the present writ petition after receiving this application. That is an admitted fact.
What? Who has not issued notice?
After receiving this application,
Commission has not issued notice.
issued a notice to the present writ petition. That is an admitted fact. We're not denying to that person.
Okay.
Yes, Worship. Worship, the decision which was taken on 22nd May 2023 on the application seeking for modification. Worship, the decision is page number 45. Worship, in order to justify the action of the commission, me allowed to read the last paragraph in page number 45. And whereas the commission, after examination of the above request for modification of its decision, that is decision number 1, accepted the above request that instead of furnishing the committee report to the applicant, no appellant, within 15 days from the date of receipt of the decision, the committee report shall not be furnished only after the government decide on the recommendation of the committee, in which 3 months' time was given to the department, as decided at decision number 2 of the commission decision dated 28/4/2023. So the commission is still sticking to its earlier decision, that is 28/4/2023. In its decision dated 28/4/2023, the first direction was to furnish the committee report, which is still pending for approval within 15 days. That was modified, but in the second decision, the commission has directed the department to take a decision within a period of 3 months. They have to finish. That is not changed. So no prejudice would be caused to the petition by this decision of the commission.
That second decision.
Second decision we have not touched. First decision, it was you have directed that
First decision was on
the first
which
decision.
date? Which date? This is 22 May 23. This is the
first-
second decision.
This is the second decision.
The first decision was on which date?
First decision was on 20
Page.
page receipt, page 30, 28/4/2023.
Page 30, no?
Page 38. First decision,
Page 38.
38.
20?
28/4/2023.
Okay.
So
All right.
in this modification later also, we're still sticking to the earlier decision, that is
Okay.
28/4/2023. The first decision was to furnish the documents which is still pending for approval. Unless, as your lordship know, unless the state government take a decision approving the recommendations of the committee, it cannot be treated as a valid.
So she is stating that this this section or rule 8 of the RTI Act.
Section 8, lordship.
So according to you, you cannot reveal certain certain documents or certain recordings, minutes, etc. to the public or to any third party or anybody.
Confidential.
And, it has to be confidential and it must not cause, I think, it must not cause chaos.
Lordship, in the commission in its
RTI Act,
Lordship, the commission in its earlier dated 28/4/2023.
you have the rules, model rules,
No, Lordship,
or the Nagaland rules or model rules.
follow the act, the central act.
Follow the act. There are rules also. So in Assam we have the rules. I think it will come in. We have rules also, RTI rules also. So the rules will be within the act, nothing
Yes, Lordship.
more than the act. So rules will be within the act.
Yeah, exactly, Lordship, within the act only. And Lordship, in the commission decision, earlier decision dated 28/4/2023, we have come to a conclusion that the information sought by the present writ petitioner, it doesn't come within the exception clause under section 8. That was our decision. We keep a decision in your favor.
Okay,
But Lordship, here also, in the modification order also, we have not altered the period of 3 months, which was passed in the earlier.
Yes, yes.
So, Lordship, however, in spite of our direction, now the department, they have taken a decision to nullify the earlier report. That is a main grievance.
Actually, that order has been reviewed. So according to petitioner, you have no power to review order under the act.
But Lordship, we have no power to review, but the order of review, it will not cause any prejudice to the writ petition. The period of 3 months, which we have earlier passed in the earlier order, that we have not altered that one, Lordship. And we have directed the department to approve the committee report within 3 months into furnishing. So this is also in your favor only, Lordship. If the department furnished him the documents which is not approved by the department, by the government, it will be of no use for them also. So we ask the department to approve it within 3 months into furnishing. However, the department take an impugned decision. By that impugned decision, the writ is just now. That is a main issue here, Lordship. The action of the committee does not prejudice the writ petition. That is all of mine.
Although at first glance, the decision modification by the NLC is not prejudicial to us, Lordship. In the first writ petition also, we have not challenged this decision because we understood that it was in our favor only, but we withdrew it in order to challenge this decision. However, Lordship, the impugned meeting minutes at page 47, Lordship, it was made, it can be understood that it was made purely to defeat the final decision of the NLC, and therefore it is bad in law, Lordship. It is done with malified intentions. And Lordship, if it is an admitted fact that there exists a committee report dated April 2021, Lordship, then it should be furnished to us according to the application and the appeal that we have made before the NLC.
Anybody is waiting for any hearing? You have a hearing? Okay. I think this will take only 10 minutes. Okay. Then we'll continue with the hearing. How many hearings? One hearing. Any more hearing? Hearing. This will take only 10 minutes. I don't think it will be something very long to decide. If there's a confusion, then I'll stop. So 2 more matters for hearing. Okay. Third Learned Counsel, Miss Imti Obangnela Longchar for the petitioner, Learned Government Advocate, Miss S. Mary for the respondent number 1, 3, 4, and 5. And Learned, you are government advocate. Standing counsel. Learned Counsel, Mr. Lima Wapa for the respondent number 2. The petitioner in this case is Sri Bhantan Muri, alias Bhantan Lutha, whereas the respondent's number 1, 3, 4, and 5 are the state of Nagaland, represented by the Chief Secretary, number 2. Number 3, the Agricultural Production Commissioner and the Agricultural Production and Commissioner and Secretary to the government. Number 4, the Directorate of Agriculture. And number 5, the District Agriculture Officer, respectively. And the respondent number 2 is the Nagaland Information Commission through the Chief Information Commissioner. Full stop. Serial likhi diba, enke paragraph kori pele likhi diba. The petitioner is aggrieved by the modification of the decision of the Nagaland Information Commission, wide number NIC stroke appeal capital hyphen 47 stroke 2022 hyphen 2023 more particular dated Kohima the 22nd May 2023, comma more particularly annexure 10 of the petition, and also by the decision dated 30 June 2023, file number AGR stroke GEN hyphen 06 hyphen stroke 2009 within bracket PT part of bracket close PT capital P small d dated Kohima the 30 June 2023, comma annexure 11 of the writ petition, full stop. An RTI application was filed by the petitioner on 9/11/2022, which is reproduced here in below verbatim, page 23. Full stop. However, the item number 2 and 3 of the RTI application were not furnished, okay, to the applicant stroke petitioner. The petitioner then preferred an appeal and then wide letter number AGR stroke RTI hyphen 2 stroke 48 stroke 2019 stroke 884 dated 13 Kohima the 13th January 2023. The appellate, this is the first appellate authority. The first appellate authority sent a reply that you got the copy of this reply, no? Sent a reply that the government stood by its earlier reply dated 21/11/2022 and the government was yet to take decision or approve the report of the committee, and thus the report of the committee could not be furnished. Full stop. It was the petitioner was also apprised that the notification dated 25 September 2009 issued by the Department of Land Revenue states that, within inverted commas, no claim for a land compensation would be entertained by the government for land falling under the British occupied territory, ... inverted commas closed. Full stop. An appeal under section 19 within bracket 3 of the RTI Act 2005 within bracket the Act of 2005 in short bracket close was preferred by the applicant as on 14 as on 14/2/2023. All right. What is APC Commissioner Secretary? APC Commissioner Secretary, full form? APC?
Agriculture Production Commissioner.
Okay. Your land was acquired by the...
Agriculture.
Okay. Listen. Next para. A notice of hearing, a notice for hearing on 19 April 2023 was circulated. Wide number NIC stroke appeal hyphen 47 stroke 2022 hyphen 2023 dated 30 March 2023. 2022 hyphen 2023 dated 30 March. So you have received a notice of this hearing. Okay. And you have participated in the hearing. Annexure 7 is the record of proceedings. Proceedings of the hearing. And the decision arrived at in the hearing. Annexure 7?
Yes, Annexure 7 has all the proceedings and the decision.
Okay. And the proceedings of the hearing and the decision arrived at in the hearing. Wide number NIC stroke appeal hyphen 47 stroke 2022 hyphen 23 stroke 1955 dated Kohima 28 April 2023. The observations and findings of the observations and findings in the hearing relating to query number 2 was that the final report was that colon di pele enke heri colon di diba dot dot aru eta heri hyphen di diba was that the final report of the committee on land issue at old DAO capital DAO office complex Wokha was submitted to the agriculture department on April 2021 and its recommendations are still under active examination and consideration. Full stop. However, since eviction was involved, the information cannot be disclosed at that point of time as per section 8 within bracket 1 within bracket small h of the Act of 2005. It was also observed that the final report of the committee was only recommendatory in nature and does not fall under the exemptions, as well as the cadastral map also. Cadastral survey also does not fall under the exemptions. Okay, exemptions from disclosure. Full stop. Regarding query number, next para, regarding not next para, sub para. Regarding query number 2. A meeting was called on 27, a meeting which was called on 27/9/2029 at 12 noon at the request of the applicant, there was no official correspondence by the department in calling the meeting and no attendance and videography were taken. Full stop.
That is regarding query number 3, not 2.
Oh, query number 3, not 2. Okay, you correct me. If there's some this type of error, you can correct me. It is submitted by the next para. It's submitted by the Learned Council for the this is an appeal, no? Oh, WPC by the petitioner that it is amply clear that a meeting was held in the month of April 2021. Gustav, it is unfathomable that when a meeting has been held and attended by officers in the higher hierarchy, there would be no recordings, video recordings, or recording of proceedings. And thus the OM number stop APPT within bracket capital B bracket close hyphen S stroke 6 stroke 68. It is not S8, no? 8. S no 8. Dated Kohima 14/9/1976. Cannot be accepted. Okay?
My submission. But there should be records of the meeting.
Cannot, so they are saying that there was no record.
Yes.
Or this is your submission?
This OM is my submission.
Oh, your submission. Okay. Etu nalage. Okay. I did not note it down. I did not note it down. I noted in that earlier I have noted and then I have mentioned the OM. Let me go through the OM first. cannot be accepted to nalage. To OM to thakibo dia, cannot be accepted to kati dia. Indicates that OM indicates that verbal discussions and minutes of the meeting ought to be recorded. This is what you have submitted. Ought to be recorded. Indicates that, full stop. So you are agreed by the decision also? Page 41?
There was no decision with regard to
Okay,
querying. It was only an observation.
okay,
So we have got this in the petition. also.
okay, okay. Which paragraph of the petition?
Uh, what is it? Paragraph 8 of the petition.
Paragraph 8.
Regarding query. At page 10, regarding query number 3.
Page 10. Okay, okay. And then decision.
And 8.1.
8.1.
8.1, 8.2, 8.3, 8.4. Yes, these are some things made in the new petition.
Next paragraph. The petitioner has contended that there was no decision made on query number 3. Commissioner? Given the decision. It kati diye. Query number 3, I have noted down. I have noted down. Hmm. Hmm. Sorry? Sorry. Hmm. Which one?
The commission decision is at page number 38 in the writ petition.
Yes, I have seen it.
And we see the observation and findings of the commission
Hmm.
regarding query number 1.
Hmm.
The query number 1 also goes against the petition.
Hmm.
And the query number 2, it goes in his favor.
Hmm.
And the query number 3 also goes against the decision. Receiving the query number
No, she has not, that's why she has not highlighted query number 1. And she has not asked also for query number 1, only query number 2 and 3.
only 2. She also, she's not challenging this decision of the commission.
No, she has challenged.
She's not challenging the query.
Query number 3.
No,
No, this final decision is not challenged, Lordship.
Final decision is not
not
challenged.
a challenge.
Their observation that it was not their decision, it was only under observation.
Hello,
So-
last line to kati diya. Okay. So you have not challenged this decision, only that 10 and 11. This was reviewed. This decision was reviewed.
Query number 2.
Query number 2 was,
Point 1 and 2 were reviewed.
point 1 and 2 were reviewed. You are challenging the reviewed decision.
Yes.
So this Annexure 9, request for modification of Nagaland Information Commission's decision. This was submitted by PIO after the final decision. Thereafter, on next prayer likhiba, 8 May 2023, wide number, wide letter number AGR/GEN-6/2009 within bracket capital PT-1 bracket close, the PIO and Deputy Secretary to the government submitted a request for modification of the Nagaland Information Commission's decision dated 28/4/2023. So you did not receive, huh? Sorry? Okay. Okay. Yes. Requested the decision of the it's okay. This I will not include in the dictation. ठीक है sir. Okay. In para 1. In para -1. Decision dated 28 April 2023 in para -1. Huh? That para 1 of the decision was to be requested to be modified from 15 days. Relating to furnishing copy No, নালাগে, irritating নালাগে। Para 1 লিখিলে হৈ যাব। ঠিক আছে, full stop. So what copies you did not receive?
Request. This
Oh.
connection line.
Oh, the learned counsel for the petitioner has contended that the request was clandestinely made as no copies were furnished to the petitioner. After this request, void. This is modification order, no? Void modification or void modification of the decision number NIC stroke appeal hyphen 47 stroke 2022 hyphen 23 dated 22nd May 2023. Dated Kohima the 22nd May 2023. The final decision was dated 28/4/2023 was modified, and the committee was allowed to furnish the report to the appellant with the not within 15 days, but the period was extended to 3 months. 3 months. Within 3 months, Lydia. Within 3 months, full stop, not within like. It is just the petitioner is aggrieved as the department was given 3 months time. As the department was as 3 months as time was extended from 15 days to 3 months. Providing the department to furnish the report, to submit the report. Okay, full stop.
If it may also be recorded that only after the decision was taken, we were given notice of this modification.
The petitioners were apprised about the extension of time to 3 months from 15 days only after the decision was taken. Okay?
Yes.
It is further contended that the respondent authorities acted beyond jurisdiction because there is no provision in the statute to review its own order. Okay. And thus, the order is liable to be set aside and quashed. As the order was passed in total disregard of the principles of natural justice. I have taken 10 minutes time, but I have taken more than 10 minutes, over 15 minutes now. The appellants have left, I think. We'll hear in the second half again. I think it will take me some more, another 25 minutes time, I think. 10 minutes time. In the second half or maybe after half an hour. After half an hour? Okay. After half an hour then. So you are landless now, or do you have some plot of land?
I have some plot of land, but that area which is occupied by
You are not compensated.
No.
Okay.
The project, that is not the issue at hand.
Maybe your agenda is known to you, I don't know. I don't think so. I'll go to, I'll take break. I'll complete this and I'll take break. The petitioner is also aggrieved by the order number by the decision by number AGR stroke GAN hyphen 06 stroke 2009 within bracket close PT hade within bracket PT part hobo dated Kohima 30 June 2023, wherein the earlier committee's report was set aside and a new committee was set up on land issues. All right? Land issues at old DAO office area, Wakha. And the committee was directed to submit its report within 3 months from the date of setting up of the new committee. Full stop. So it was also decided that the matter on the land issues of the same area shall be placed before the advisor stroke minister in charge along with the report of the new committee, full stop, and to write to the CIC stating that the government is in consideration of the case and accordingly it has set up a new committee, full stop. It's okay? Within bracket, annexure 11. Per contra, learned government advocate, no?
Yes.
On behalf of respondent number 1, 4, and 5.
1, 3, 4.
Oh, 1, 3, 4, and 5. Let's stress in our argument that the government has power to set up a new committee.
Yes, yes.
Okay. And thus the new committee and thus the committee's report has to be forwarded to the government for approval.
Yes, yes.
Okay. The Learned Council has also the learned government advocate, senior government advocate,
Senior government.
learned senior government advocate लिखिए वहाँ. Senior government advocate has also submitted that in the final decision it was also decided, final decision, no? That page 46,
Page 46.
not final decision. This is not
Yes,
the final.
yes, based on this.
Oh, yes, yes.
Based on this.
In the
page
modified,
46.
okay.
Yes, page 46.
That in the modified order, it was also in the modified the order impugned by the petitioner. This has been impugned, no?
Yes. yes.
Impugned by the petitioner. Modified order dated 22/5/2023, comma, impugned by the petitioner. It is reflected that the commission decided that the committee report shall be furnished to the applicant only after the government has taken action on the recommendation of the committee. Huh?
Yes, yes, right.
And for which 3 months time was allowed as requested.
Yes, yes. Your ladyship also may record that the first committee report has been nullified
It is further submitted that the first committee report has already been nullified
due to lack of documentary evidence.
owing to lack of documentary evidence.
Yes. And the setting up of the new committee.
And
is
of course,
in
on
superstition, if your ladyship may, kindly see page 12. The notification.
12.
Yes. Page
And
12
of
my
course,
affidavit.
okay, and of course, on setting up of the new committee.
That is in superstition of the notification dated for.
In
the
supersession,
committee.
in supersession of the notification dated, setting up the new committee, page 12, no?
Page 12.
1, 2, 3, and 5.
Yes.
No, this is 2, respond number 3.
1, 3, 4, and 5.
1, 3, 4, and 5. Affidavit in reply. Affidavit in opposition, respond A. Page 12. And setting up of a new committee, wide notification number in supersession to Nalaibar, setting up a new committee wide notification number AGR stroke GEN-6 stroke 2009 within bracket. I think we have discussed this notification now. PT bracket close dated Kohima the 25th August 2023. Annexure E of the affidavit in opposition submitted by respondent number 1, 3, 4, and 5
Yes.
is the notification. Okay. So according to you, all the queries were replied.
We are saying that we cannot furnish, which is not documented.
Uh,
And therefore, the first committee report has been nullified. So accordingly, as per the provision under the executive rules, a new committee has been set up. And that committee is yet to submit its report. Yes.
It is submitted that the queries which could be furnished have the reply of the queries which could be furnished have already been provided to the appellant, but the undocumented
Yes, yes.
minutes and proceedings of the meeting could not be furnished to the appellant. And thus a new committee was set up.
Yes, yes.
And after nullifying the first,
First committee report.
after nullifying the first committee report, full stop. The learned counsel, the learned senior government advocate has drawn the attention of this court to the Nagaland Rules of Executive Business, Part 3, Departmental Disposal of Business, within bracket, capital A, bracket close, general, wherein as per, this will be clause or rule.
Rules.
As per Rule 29(1), Rule 2,
Rule 6.
Rule 29(1), no?
Yes, Rule 29(1).
Rule 29.
Sub-rule 6.
1 to heri kori diba, uthai diba, A2 herit ase. Affidavit in opposition of 1, 2, 3, 1, 3, 4, and 5, page number 9 ot ase. Rule 29(1).
29 sub-rule 6.
Eto pink tag ase. Affidavit in opposition 1, 3, 4, and 5. Annexure C, page 9. Annexure C, page 9. Eto petition no hoy. Affidavit to sini paba na, kenke uliabo lage. Then page 10.
Page 10.
Sub-rule
6.
6.
ABC.
ABC, hetu tuli diba. And
31.
Rule 31. Etu tuli diba, ha? Etu mazot star di diba. Eta rule continue no hole, discontinue hua mazot star di diba. Etu 29(1) gute tu likhiba de. Pura ke likhiba. 2 to nalage na. 29(1) sub-rule 1 gute tu likhiba. 2 or 3 to nalage. 4, 5 o nalage. Ako 6 likhiba. Gute tu. 6 o gute tu nalage. 6 or na gute tu lagibo. A, B, C. 6 small A, B, C. Now, at present, it is further submitted that the report has been submitted.
Second committee report is yet to be submitted.
It is further submitted that the second committee report is yet to be submitted and placed before the government.
Yes, yes.
So I'll allow you some time to place the report. Or what? What to do? There are rules in place. And then you could not review the order also, but you have reviewed. So what to do now? And if we set aside also, you will not be benefited. If you set aside, you won't be benefited. The matter is under process. if we set aside, you see you are aggrieved by occupation of your land. And if you set aside this order, you won't be benefited. They have gone beyond the jurisdiction and reviewed its own order. No doubt about it. If there is no scope for review, I have read the act long time back when I was PIO. So now I have forgotten. I do not believe there is scope for review. 8 I remember, but scope of review, so they have reviewed it. Erroneously they have reviewed it, no doubt about it. We can give a direction to, as it is more than 2 years, they have not submitted the report. We can expedite and submit the report. But what will the government do thereafter? That is up
Yeah,
to the,
that is.
we will have to leave it to the government then.
Yes, yes.
Yes, Lordship, beyond this meeting minutes, what happens is not under our scrutiny right
Yes.
now, but
Mm.
the meeting minutes itself, Lordship, my submission is that this meeting was held and the decision was taken to defeat the whole purpose of the process that we followed under the RTI Act, reaching up to the NIC, Lordship.
Mm.
So,
Mm.
in that
It
view,
was
Lord-
held with Malafide,
Yes,
according to
Lordship.
you. At best, maybe, at best we can direct them to submit the report expeditiously.
Lordship.
Huh? We didn't say they were given 3 months, but they have taken maybe 2 years, I think, no?
That may be in the interest of the petitioners.
Hmm?
That may be in the interest of the petitioners. Otherwise, the petitioner failed to disclose the information sought is in the interest of public. That is not there. So
Learned counsel for the learned standing counsel, learned advocate Mr. So and so for the respondent number 2 has submitted that. The final decision is at par with the earlier decision, according to you.
The modification later, the modification order.
The
Also,
modified order.
That's also in terms with the earlier order.
Has submitted that the modified order impugned by the petitioner is also in terms with the earlier order.
Earlier order dated 28.
Dated 28/4/2023. Okay. Does the order impugned by the petitioner has not prejudiced the petitioner at all?
Exactly.
In reply, the learned counsel for the petitioner has submitted that at first blush, the petition may not appear, or the modified order may not be and may not appear to be prejudicial, but the review was, but the earlier order was modified with Malafide.
Of the principle of mutual justice.
On the principles of natural justice and also the impugned meeting minutes, the decision was based on the modification that was made by the NIC. The review was with Malafide to Katidia. But the meeting was but the modification, but the review order, but the review was against the principles of natural justice, full stop, and the full stop. Decision made by the minutes, page 47, is also on due to the modification made by the NIC, which has caused prejudice to me.
petitioner has been highly prejudiced by the order, by the decision dated 30 June 2023, which was arrived at with malafide. I have considered the submissions at the bar with circumspection. I don't know, like I have considered the submission in Nalai. The petitioners were indeed, the petitioners were, respondents were indeed directed to submit their report within 3 months, but no report has been submitted. The petition highly prejudiced by the procrastination. Who stop? And thereby, this court deems it appropriate to direct the respondent authorities deems it appropriate to without Lihida, the highly deems it appropriate to direct the respondent authorities to submit the report, respondent authorities commission, and the new committee and the newly formed committee.
The committee has been constituted by the state government, not by the commission. And as per this.
So who will submit a report now? Who are the respondents now?
Respondent number received, it will be
More particularly, respondent authorities more particularly.
number 3 and 4.
3 and 4.
No, Rashid, the chief secretary has taken the impugned decision. So he's also a necessary party. 1, 3, and 4.
1, 3, and 4 to including the newly formed committee. Or not, including the newly formed committee by the order dated.
Notification also.
By notification dated
25th August 2023.
25th August 2023 to submit to forward their report before the government within 3 months from the date. Within 3 months or 2 months? 3 months.
Rashid, as per the
Your time is itself within 3 months from the date of this order. Okay.
In the notification itself, it's dated 30th November 2023. So already in 2025.
3 months. 3 months from the date of this order. In terms of the above application, this petition stands disposed of. Okay. Anything else if you want to add?
Rashid, after the new committee submitted the report, if so advised, the petitioner may apply for, he has to apply a fresh application for the new report.
And it is, if so advised, when the petitioner submits the report, when the department submits the report, the petitioner may apply afresh for the for the information for relevant info for information sought under the RTI Act. Okay, under the Act of 2005. Anything else to be added? It's okay.
That will suffice.
Okay, all right.
May I please, my lord?
Yes.
Lordship, with a sincere apology, lordship, I beg my lordship indulgence, if I may be allowed to mention item number 17, your lordship. This, your lordship, I have overlooked the custody this morning during the mentioning hour, your lordship.
Item number 17?
Yes, my lord. If this matter can be listed on Monday, my lord.
Monday?
Yes.
Okay. Learned government, senior government advocate.
Yes, my lord.
Mr.
N. Angami.
N. Angami.
For the petitioner.
Okay. With the consent of learned counsel for the petitioner Menosino, has prayed for adjournment, list the matter on Monday. Date, okay. Interim order shall remain in force till then. What is the date on Monday? 11th? 11th August. Yes.
For hearing, item number 16.
This fan on.
May it please your lordship. Lordship, the petitioner hearing is seeking to quash and set aside the appointment order of the respondent number 5, the private respondent number 5.
Yes, yes.
As the appointment of the private respondent is in violation of the office memorandum dated 16/08/2018 and in violation of the judgment order dated 27/03/2024 passed by the division bench of this honorable court.
Okay.
May I take my lord to the office
16
memorandum?
office member
16/08.
quashing appointment order dated 16?
No, quashing appointment order dated 12/08/2024.
12/8/24 of respondent number 5.
Yes, private respondent number 5.
Oh, respondent number 5 is present?
Yes, my lord.
Okay.
As the same is in violation of the office memorandum dated 16/08/2018 and in violation of the judgment dated 27.
Violation of OM number?
OM dated 16/08/2018
And?
and in violation of the judgment dated 27/03/2024. 27/03/2024 passed by the division bench of this honorable court.
27
03
27 3.
2024.
Okay.
Now may I take my lord to the OM dated 16/08/2024. My lord, may kindly turn to page number 41, annexure C2 of the petition.
41.
Yes, my lord, page 41. Yes, my lord, the relevant portion is at para 3, subclause B. Para 3, subclause B. May I read, my lord? It is also clarified that it is not the policy of the government to provide employment or other facilities to the landowners in perpetuity. The employment or other facilities of landowner, if permitted by a variable and a valid agreement, is limited to the first person appointed as landowner in the government service and does not entitle his descendant for further employment. My lord, this is important.
Yes.
So, my lord, the case here is that.
I read this office memo not very long ago, no?
Yes.
You have submitted, I think, this office memo. In another case, you have submitted this office memo.
In this case, he has collected the office memo. Yes, my lord.
Oh, no, not you have submitted, I think. You have submitted in another case. But here,
He has collected.
Okay.
The government has collected. So, my lord, here, there are 11 landowners who gave their land for setting up the veterinary dispensary at Jakama village. So the office was set up, 11 landowners, and out of which one Kuzon, he is also a landowner, Kuzon.
you are Kuzon or
Yes, my lord.
that respondent number 5 is Kuzon.
Yes, he is the descendant of Kuzon.
Okay, descendant.
More particularly at para 10 of my petition, page number 6, para 10. So, my lord, here, Kuzon was a landowner. And basing on the land ownership of Kuzon, one Tepuseo Tase already availed the benefit. He already availed the benefit. Since Kuzon was the landowner, Tepuseo Tase was a descendant of Kuzon.
Respondent number 5.
No, one Tepuseo Tase.
One
Tepuseo Tase.
Tepusewol Tase.
Yes, who is a descendant of Kuzon. He is a descendant of Kuzon. He has already availed the benefit. He has already availed the benefit to be appointed on the basis of land ownership. And now he has retired. Tepuseo Tase has retired, and his retirement created the present post. This is animal attendant. And now the respondent number 5. The respondent number 5 is also a descendant of Kuzon.
Okay.
And the state government, in violation of that office, appointed the respondent number 5. So from one family, 2% are already appointed, my lord. 2% have been appointed. That is why I'm agreed, my lord.
Okay.
Because beyond one, the policy of the state government is not to give the benefit of appointment in perpetuity, my lord. If one family member availed, then it's gone. The right is gone.
Hmm.
Now coming to the judgment of this honorable court, the division bench of this honorable court. My lord, the judgment in writ appeal 11 of 2023 at page number 34, but the relevant para is at page number 39. Page number 39. So my lord, I'll just give a gist. This is the third round of litigation. This is the third round of litigation. Previously, the husband of the petitioner filed a writ petition where this honorable court, the single bench of this honorable court by an order dated 16/10/2023 was pleased to quash and set aside the appointment of the respondent number 5, as it was not in consonance with the office memorandum.
Where is the order?
At page number 24. Page number 24, my lord. 16/10/2023, the first round of litigation. Then, in a brief, the private respondent number 5 filed an appeal, numbered as with appeal 11
Page,
of-
that order is at page 24.
Yes, my lord.
Okay.
Page 24.
Page
In
24.
agreed by the order, the private respondent filed an appeal, numbered as with appeal number 11 of 23. Thereby, the honorable division bench refused to quash and set aside the order of the single bench. However, modified it to the extent that an advertisement will be given by the department, inviting only the landowners. Inviting only the landowners. So an advertisement was given, inviting only the landowners to fill up the vacancy. Inviting the landowners to fill up the vacancy. However, my lord, there was a condition. If my lord may kindly turn to page 39.
Page
39, my
39.
lord. Of the judgment and order dated 27/03/2024. Page 39. May I read, my lord?
Yes,
Not
yes.
read.
Yes, can
This
we?
was the decision given by the division bench of this honorable court.
Para 9 years.
Yes, my lord. Having heard the learned counsels for the parties and after considering the matters in its entirety, we are of the considered view that the matter of filling up the post in grade 4 at veterinary dispensary Jakama shall be strictly, my lord, this is very important, shall be strictly in terms of the office memorandum dated 16/08/2018. Advertisement was given, but the filling up of the vacancy was to be strictly as part of office OM, office memorandum dated 16/08/2018. Despite that, in violation of the office OM and in violation of this honorable court, the division bench order, the state respondent has appointed the respondent because his descendant has already availed the benefit once, so they cannot avail it twice. And now here my case is that the petitioner, the petitioner's clan, the Richard clan, there are 11 landowners. One of them is Richard clan. They also gave it land. The Richard clan also gave land for setting up the veterinary dispensary at Jakama.
Okay.
Yes, until date, not a single person has availed the benefit to be appointed on the basis of land ownership on behalf of the Richard clan member. Till date, not even one person has been appointed. Avail the benefit on behalf of the Richard clan member.
Okay.
Yes, my lord, it is a fact that 2 members of my clan has already been appointed, 2 members from Richard clan, but those fellows, they gave their private individual lands. Yes, they also gave their land. Two members of my clan, from Richard clan. It is a fact that they have already received appointment, but they have given their private individual land. they have never availed the benefit on behalf of the Richard member. They have given their private individual lands. And basing on that, they have availed the benefit.
They have given their private individual lands, but not as descendants.
No, no. They have given their private individual lands and they have availed the benefit. But my clan, the Richard clan, also gave a portion of the land. The clan also gave a portion of land. But till date, not a single person has availed the benefit on behalf of the clan.
Okay.
Yes, not a single person has availed the benefit on behalf of the clan. Not a 2% from my clan was appointed, but they gave their own private individual lands. So they are entitled on these private individual lands.
Okay.
But till date, not even a single person from my clan has been appointed on the basis of land ownership. The benefit of the clan's land, not a single person has taken, my lord.
Okay.
Therefore, being aggrieved, my lord, and the newspaper was published, advertisement was published in newspaper. I appeared for interview. The respondent number 5 also appeared for interview. We were the only two candidates who appeared. But the direction of the division bench of this honorable court was very clear. The filling of the vacancy was to be as per that OM. Advertisement no doubt was issued, but it was to be as per the OM. That was the strict
All right.
direction.
Okay. You see, this okay.
Yes, that was the strict direction of the state government in violation of the judgment and in violation of its own OM, has appointed the respondent number 5 again. From that I am aggrieved, and therefore I am praying to quash and set aside the appointment of the private respondent number 5.
As what? What is the post? View?
Animal attendant.
Animal
grade 4 post.
attendant,
Yes.
grade 4 post. Okay.
Grade 4 post.
Yes.
Therefore, I'm praying to quash and set aside the appointment of the respondent number 5. And also, I'm praying before this honorable court to direct the state respondent to consider me for appointment. As I'm also a layman, I have never availed the benefit. This
Yes,
is my
yes.
submission, my lord.
I don't take much time here.
Yes.
I'd like to. I take your leadership. May I take
For
your
all the
lead-
respondents, 5 year for 5, 1 to 4,
Private respondent.
1 to 4.
Wonderful. May I take your leadership to page 39?
Page 39
Page
WPC.
39,
Mm.
last,
Oh, that order.
from last, if I read, 1, 2, 3, 4, 5, 6, 7.
Mm.
7 lines from the last.
Okay.
The operative para.
Okay.
This is the order, judgment and order passed by the
Deep.
Learned Division Bench. The state respondents,
Mm.
while proceeding to fill up the vacancy in the grade 4 post at the veterinary dispensary, such and such, shall invite applications from eligible applicants claiming appointment on land ownership basis by virtue of the agreement dated 18/12/1975 with wide publicity, and thereafter to proceed to complete the entire exercise as expeditiously as possible, preferably within a period of 4 months from today. It is needless to say that the cases of the applicants are to be considered on the basis of authentic supporting documents. As my learned friend has said, only 2 candidates were appeared. Because both of them are agitating that they are the landowners. So, and as per the direction in order of this single division bench, we have conducted everything. I'll take your leadership to state counter.
To?
State counter affidavit filed by
Okay.
the
Your counter.
counter affidavit filed by the state.
Affidavit in opposition. Yes.
Yes, page 2. Yes, page 2, number 2.
Page 2.
Page 2, paragraph 2.
Okay. Page 2.
This is This is
Hmm.
I am disputing the maintainability of this writ petition
Hmm.
on the ground that. May I read your ladyship?
Yes, yes.
Number 8.
Hmm.
That the petitioner has no locus standi to file the present writ petition against the state respondents.
Hmm.
It is submitted that the petitioner has participated in the selection recruitment process conducted by the department. That means your ladyship, please appreciate,
Hmm.
conducted by the department means as per the direction, order and direction of the division bench.
Hmm.
And as such, at this stage, the petitioner cannot turn around and challenge the non-selection of her candidate because she has participated. As we have conducted the selection process as per the direction and order of the division bench. The petitioner cannot agitate before this Honorable High Court as the petitioner is barred by the doctrine of Snowden, which states when one person has by his declaration, act, or omission intentionally caused or permitted another person to believe a thing to be true and to act upon such belief, neither he nor his legal representative shall be allowed in any suit or proceeding between himself and such person or his representative to deny the truth of that thing. That means the leadership, please appreciate, he has participated in the selection process. He was not selected on the basis of the merit. Now, he has participated, he is coming and agitating by way of this writ petition. So at the threshold, without going under the merit of the case, it has to be dismissed. This petition
Now,
deserves to
tell
be
me,
dismissed.
will it be barred by res judicata? Will it be barred by res judicata?
Maybe that is also another yes. That may be even bad by the res judicata. He has participated. We have conducted the selection process as per the direction of the Honorable Division Bench. And the petitioner has participated. He was not selected. He was not selected on the basis of the merit. As my learned friend has said, only two of them has participated. That means the petitioner and the private respondent. So amongst two, we have to select one. So accordingly, we have selected the private respondent. State has very clear, and he has not challenged the legality of or illegality of the selection process also. He's not challenging that. Selection process has been done. And that petitioner who was fit, we have selected. That is one point which I want to apprise your leadership. Leadership, please come to para 7. I'm sorry, para 5. That with regard to the statement made in para 2 of the writ petition, the answering deponent begs to state that the Department of the answering deponent has purchased a land from the landowners at the rate of rupees 1,500 only, and date of release was executed on 10/10/1975, wherein the landowners declared that all the rights and injuries of their own have been fully and satisfactorily compensated, and affirmed that on the day of the date of release, renounced, relinquished, surrendered to the government, and has appended their term impression signature witnessed by Tapashi, countersigned by Legal Officer Chakama. That means this is a document which was executed during 1975. So, your Lordship, please appreciate the sell date of release. Lordship, you will find the date of release. Lordship, you'll find the date of release. Yes, in page 10. No. Date of release is in page 8. It is given as date of release, which has been signed by this Legal Officer Takama District, Kohima, 10/10/1975. That time, there was no judicial magistrate There was no known
Yes,
public
yes.
notary.
Yes.
Long time.
I know, I know.
Only circle officer.
Only executive magistrate.
Only circle officer was in charge of a block.
I know.
So it was done by whatever governmental procedure available. It was done in the lake. Now I'll take your leadership to continue to the content. Page 4, paragraph 7. That with regard to the statement made in paragraph 6 of the writ petition, that as per the direction of the Honorable Court judgment and order dated 1/12/2023 and writ bill number 1 of 2023, the post of animal husbandary at veterinary hospital Kohima under the establishment of chief veterinary officer Kohima was advertised, your lordship, your ladyship. It was advertised, and the petitioner, along with 3 other applicants, applied for the post by advertisements number so and so dated 15 July 2024. However, the 2 applicants were rejected to undergo interview due to overage. And the department conducted the interview for the 2 applicants, that is the present petitioner and the respondent number 5. So only 2 we have conducted only for 2. Leadership come to paragraph 9. That with regard to the statements made in paragraph E of the writ petition, the recruitment, selection, and interview was conducted as per established procedure by open advertisement, wherein all eligible candidates were invited and the selection was carried out fairly, strictly, and then merit on the basis of the merit. So it was done. And the petitioner now herein is not challenging the selection process. He is just claiming that he is the landowner basing on the notification of the appointment of land ownership. I'll come to that.
He's challenging the selection process.
I'll come to that aspect of the meeting.
So we'll come after lunch then? After break? After break?
After break, let me
You'll finish. You'll finish before break. We have only 5 minutes.
I can finish.
Okay.
Because I have a conference at
Okay. You finish it.
1:30.
Okay.
My side is very short. And
Okay.
my
Then
other friend will.
his side will come after break.
After break, he can submit. But let me complete my submission. 11. Lordship, page 6. That with regard to the statement made in paragraph 11 of the writ petition, the appointment was done following the procedure of law, inviting eligible candidates limited to landowners, as per Honorable High Court order for an open interview. Therefore, one who secured highest marks and person merit was recommended for administrative approval for appointment. Lordship, that's all. From my side, from the state, we have just carried out what has been directed by the Honorable Division Bench of this court.
Okay.
What has been directed by the Honorable Bench of this court. Because the direction was very clear. Open advertisement, invite all, select. We have done that. So that is my short submission, Lordship.
My lord, just 1 minute. Countering the submission of the state respondent. They have complied with only half the direction. Advertisement, selection, but they forgot the first part of the order. For the selection process is to be strictly as per the OM. They have not followed that. The direction was to be strictly as per that OM, and the state respondent have not followed that.
Okay.
Yes, my lord. That is my humble submission. Countering the submission of the state respondent.
No, your Lordship, your Ladyship, I'll clarify that. I'll clarify that, which has been projected by my.
OM dated 16/8/2018.
18. Yes.
Page 41 of the writ petition, Ladyship. Please turn to page 41. Annexure C of the writ petition. Here's a policy decision of the state. 16 August 2018. With regard to appointment of land owners on land ownership right.
Yes.
I'll take your lordship to the last paragraph, that is para 3B. It is also clarified that it is not the policy of the government to provide employment or other facility to the landowner and perpetuity. The employment or other facility of landowner, if permitted by verifiable and valid agreement, is limited to the first person appointed as landowner in common service and does not entitle his descendant for further employment or other facility under retirement from service. From service vacates the post. After retirement from service vacates the post. After the appointed landowners retires or vacates the post, the vacancy will be filled up through open advertisement and in consonance with the existing government policy, giving equal opportunity to all applicants. This OM, it speaks about suppose certain land and a certain land. Certain land belongs to me only, and I'm appointed. In that case, my descendant, my son, my daughter will not be allowed. That is what. Here in the case, the complexity, that should be place appreciate. Many people has donated the land, not only one. He's claiming that he's one of the landowners. His plan has not been done, but the private respondent has been second time appointment. That is why. In that case, in order to have an equal opportunity of employment, as envisaged under Part 3 of the Constitution, we have to conduct an interview. Though it is not said here, in all fairness, state has to proceed with the selection process among the landowners. Because there is a conflict between the landowners. I'm saying I'm also landowner. Okay. He's saying he's also landowner. About 6-7 of them are landowners. That is how we invited the eligible candidates among those landowners, asked for the direction in order of the Honorable Division Bench, and selection was done.
Okay.
That is the thing. That is the interpretation of this notification 16 April 2018, Para 3, Clause B. That is the interpretation. So, leadership, I appreciate for your patient hearing. That is from the state.
Okay. All right, we'll come back at 2.
Oblige, my lord. Oblige.
We'll leave at this.
and in arguing for the further response,
Yes.
can you permit me to place three short arguments?
Sure.
Two on preliminary grounds, technicalities. So first argument is that as the learned government, senior government council have argued that a person, if one subjects oneself to an exam to process voluntarily, even in this case, the petitioner, she had on her own volition, voluntarily sat for the interview. And after sitting for this interview without any demerit, now she has challenged the decision of the interview board. Had she been selected, she would have most happily embraced the result of this committee. However, since this result was rendered not in her favor, she has come before the court challenging the result. And my lord knows that this is not permissible in law. And to support this argument, kindly permit me to furnish two decisions of this on the court. First is Worship, this decision was rendered by this court in one Besas versus State of Nagaland. The relevant para, my lord, is at para 17. I just flagged the relevant portion. Can you permit me to read this?
Yes, please.
It is well settled law that if a person takes a calculated chance and appears at the interview, then only because the result of the interview is not palatable to him, her, he cannot turn around and challenge the selection appointment of the successful candidate and for contend that the process of the interview or the methodology adopted was unfair.
Para 7?
Yes, 17, madam.
Oh.
17.
No wonder. I was looking at para 7. Yes.
I'm sorry.
Okay, it's okay.
I'm at the middle of the paragraph. It is also seen that the interview of the board was conducted on 30/11/2015 and the result of the interview was declared on the same date and the order appointing the respondent number 5 was issued by the department on so and so. However, it is only on 6/11/17 that the present writ petition was filed. It is therefore very obvious that the petitioner was taking a calculated chance and observing as to whether the action taken by the village against the appointment of the respondent number 5 would work out to her advantage. And it is only when all such attempts failed, the present writ petition was filed. Lordship, also, this court had relied on a Supreme Court decision. Since I'll be referring to only High Court decision, can you permit me to read the first portion of this Supreme Court decision? Immediately from Madras Institute of Development Studies versus and another versus so and so. The Honorable Supreme Court held that as the respondent, without raising any objection to alleged variations in the contents of the advertisement in the rule, submitted his application and participated in the selection process by appearing before the committee of experts. It was only after he was not selected for appointment that he turned around and challenged the very selection process. Curiously enough, in the writ petition, the only relief sought for is to quash the order of appointment. If emphasis may be given on this, to quash the order of appointment without seeking any relief as regards his candidature and entitlement to the state post. Next paragraph, please. In Madanwal versus State, Similarly, has been reiterated by the bench, which held that before dealing with this contention, we must keep in view the silent fact that the petitioner, as well as the contesting successful candidates, being respondents concerned herein, were all found eligible in the light of marks obtained in the written test, to be eligible to be called for oral interview. Up to this case, there was no dispute between the parties. The petitioner also appeared for at the oral interview conducted by the members concerned of the commission who interviewed the petitioners as well as the contesting respondent concerned. Thus, the petitioner took a chance to get themselves selected at the state oral interview. Only because they did not find themselves to have emerged successful as a result of their combined performance, both at written test and oral, they have filed this petition. It is now well settled that if a candidate takes a calculated chance and appears at the interview, then only because the result of the interview is not palatable to him, he cannot turn around and subsequently contend that the process of the interview was unfair or the selection committee was not properly constituted. Lordship, I believe that would suffice insofar as this case is concerned. And also, Lordship, another rendered by this court. If Lordship will have paragraph 13, I flagged the relevant page. Can you permit me to read this?
Yes.
It is to be mentioned here in this context that while dealing with the issue of the case of Om Prakash Shukla versus Akhilesh Kumar, for the AR, so a chief judgment of the Honorable Supreme Court has held, when the petitioner appears at the examination without protest, when he found that he would not succeed in the examination, he filed a petition challenging the state examination. The High Court should not have granted any relief to such petitioner. Lordship, paragraph 14 also, if I may. Thereafter, in the case of Madallal, the Supreme Court, before dealing with this contention, we must review the silent fact that the petitioners as well as the contesting successful candidates being concerned respondents hearing were all found eligible in the light of marks obtained. Lordship, even in this decision, the facts is rather similar. On the basis of land ownership, this was contested. However, since the petitioner had on their own volition set for the exam, later they were not allowed to challenge the result because they have subjected themselves, Lordship. So that is my first argument, Lordship. The next limb of my submission, Lordship, is that in the entire petition, Lordship, more particularly the prayer, the petition has never assailed the selection process, Lordship, contrary to what I believe my
Yes,
Lordship has
yes,
stated
stated.
earlier. Kindly permit me to develop this argument. The selection process has not been challenged in the writ petition, Lordship. The petitioner, at the time of interview, I've also made this averment in my affidavit. She had also met the respondent, me, at the place of interview. And during this time, no complaint, written or oral, was ever made to the authority concerned. Even after the interview was held, immediately, perhaps if at all, she was indeed aggrieved by this, perhaps an RTI could have been filed. Lordship, the state affidavit, there, the state council, they've enclosed documents such as minutes of meetings, result declaration, submission of the interview, or a report by the submission, or for that matter, mark sheet also. All this, in my humble submission, constitute the selection process, and therefore, had the petition been addressed challenging the review selection process, then all this ought to have been challenged. However, if my lord will kindly have the writ petition, Lordship, the prayer portion more particularly, if my lord will kindly look at page 7 of the writ petition, or shall I just read it for the court, Lordship? So I'll just permit me to read this. The prayer in this writ petition is in the premise.
So according to you, did not challenge the order of appointment?
They have just jumped. They have just hop, skipped and jumped over the entire selection process, and they are only challenging the appointment order, Lordship, which is not permissible in law. As per the prayer, Lordship, kindly permit me to read this because in the premise, it is therefore great that your lordship may graciously be pleased to admit this petition, issue rules calling upon the respondent to show cause as to why a writ as prayed for should not be granted, all for records, and on perusal of the same after hearing the parties, be pleased to make the rules absolute by 1. Directing the state respondents to adhere to this agreement dated 8/12/75, order dated 27/3/24, passed by the division bench of this honorable court in writ appeal 11/23, and the office memorandum dated 16/8/2018, and consider the appointment of the petitioner to the grade 4 post at Veterinary Dispensary Jakama under Chief Veterinary Officer Kohima, Nagaland, on the strength of being one of the landowners. 2, Lordship, and further direct the order number so and so dated 12/8/24, passed by the state respondent, to be quashed and set aside. This is the impugned order by which I've been appointed as animal and Lordship. And 3 is that, or to pass.
So what has she not challenged, petitioner?
Lordship, my humble contention is that the entire exercise, Lordship, if even going by the records that we have furnished by if my lord will have the affidavit filed by the state government, Lordship, herein the state, they have furnished minutes of interview held on 24/7/24 for recruitment of the post.
Legality of the selection process not challenged.
Yes, Lordship.
Okay.
So many documents are there. This ought to have been challenged because, Lordship, even going by the merits, the division bench, I'll just develop that argument later as well, that division bench has not barred me. It has more particularly stated very clearly that the petitioner, as I was then, is not barred from sitting for this interview. And accordingly, an advertisement was made. I had duly participated, and the interview board in its wisdom had selected me. Therefore, the process, if at all, the petitioner was briefed with the process, then the not just assailing the final order, but the provision, the selection process ought to have been challenged. And without challenging the revision, the selection process, the petitioner cannot legally challenge the two decisions which I furnished before my lord also. It's on the same line. And coming back to the argument that coming back to the argument that in the prayer portion also, nowhere has the petitioner incorporated the fact that the entire selection process has to be washed and set aside. With that, in fact, I wanted to place one argument, one decision rendered by the Honorable Apex Court. Thank you, sir.
Okay.
Lordship, para 14.
Yes.
Yes. So this judgment is regard to a prayer which is not there. If at all a prayer is not agitated in the petition, then that prayer cannot be allowed, Lordship, for the reason that petitioner cannot travel beyond the pleadings. Lordship, kindly permit me to read this. Para 14. Reverting to the preliminary objection raised by the responding state, as already mentioned above, there is no reference to the GO in the entire writ petition. This document is not even part of the writ petition. Therefore, there are no foundational facts or pleadings in the writ petition challenging the GO as unconstitutional. More importantly, there is no prayer in the writ petition seeking quashing of the GO, even when the learned counsel for the state has pointed out fundamental inequality in the writ petition. No attempt was made by the petitioner to amend the writ petition so as to incorporate challenges to the state GO as well. In the absence of any pleadings and the prayer seeking quashing of the state GO, it is not permissible for the petitioner to seek a relief by making oral submission on this behalf, Lordship. Also, one last decision of the Supreme Court, Lordship, on the same argument that the contentions cannot go beyond the pleadings, Madam. If Lordship would permit me to read paragraph 16, 17, and 18.
Yes.
Coming to address the second issue, while the court is not appetitive predicament of the respondent grandparents, it is a fact that absolutely no relief was ever sought for them by the change of surname of the child to that of first husband, son of respondent. It is settled law that relief not found on pleadings should not be granted. If a court considers or grants a relief of which no prayer or pleadings was made, depriving the respondent of an opportunity to oppose or resist such relief, it would lead to miscarriage of justice. Paragraph 17, my lord. In the case of Procedural versus RM Nagapa, this court considered the issue as to whether relief not asked for by a party could be granted, and that too without having proper pleadings. The court held as under. It is settled that decision of a case cannot be based on grounds outside the pleadings of the parties, and it is the case neither that has to be found. Without any amendment to the plain, the court was not entitled to grant the relief not asked for, and no prayer was ever made to amend the plain so as to incorporate in its alternative case, my lord. Last paragraph, please. In the case of Bharat Gauhati versus Dosun Khan, though the court has very wide discretion in granting relief, the court, however, cannot, ignoring, keeping aside the norms and principles governing grant of relief, grant the relief not even prayed for by the petitioner. Also, that is the simple point that I wish to convey through that argument. And what to come to the final argument is that there is no contravention of the direction given by the Honorable Division Bench of this court. If my lord may kindly permit me to read the judgment, the relevant portion. My learned friend has enclosed a copy of the Division Bench decision in the writ petition.
Yes.
There. Kindly permit me. As the direction has been made to filled up resulted vacancy of grade 4 at the veterinary dispensary Jakama strictly in terms of OM dated 6/8/2018. The cancellation of the appointment of the repetent respondent number 5 by the learned single judge shall not operate as a bar for him to stake claim for appointment on the basis of then ownership vis-a-vis the petitioner respondent number 1, Lordship. Therefore, it was made abundantly clear that I was not barred from sitting from the exam, and therefore, responding to the advertisement that was made by the government, I have applied, and my candidature was considered by the board, my lord. Therefore, this consideration, the process, has not been challenged by my learned friend, and therefore, it is my humble contention that the petitioner cannot circumvent the procedural law, my lord.
Okay.
Yes, and therefore, to sum up, the petition has to be at the very threshold for the reason that the entire selection process has not been challenged, Lord.
Okay.
May it please your lordship,
Mm.
my lord,
Mm.
countering the submission of my.
Yes, yes, yes.
This is a very unique case.
Mm.
The citations relied upon by my learned friends, there was no condition, but here, in this present case,
Mm.
the division bench of this honorable court has strictly given a condition that the filling up of vacancy is to be as per the OM.
Mm.
As per the OM. So the only question arises here in this case is whether the state respondent fill up the vacancy as per the OM, and the answer is no. They did not follow the OM while filling up the vacant post, because the respondent number 5 has only the descendant of Kuzon.
Plain and simple.
Yes, my lord.
Yes.
Yes. Only that question, whether the state has followed the OM. That's all.
Lord,
That is my humble submission, my lord.
Stick to my argument that, Lordship, had she participated, had she been selected,
I have
she
two
would
questions.
embraced the seat.
I have two questions. One is almost answered. See, whether this case is barred by res judicata. I think no.
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 I do not think so. No.
No, yes. I also think so. It's no. Not barred by res judicata. Another question is that your ancestors have already got an appointment in 2 posts. So now how can they stake claim over the same post? Huh? Being an ancestor?
Yes.
Can you stake claim?
No.
Being a Rizo and being a Rizo clan? Already,
clan.
already,
No.
already 2 have got an employment.
No, my lord. No.
No.
No. The Richa clan, 2 of them got. That is a fact. But they have donated their private individual lands.
So per plot of land, not per clan. That,
is the
what is the criteria? See,
the-
per plot of land or per clan?
That is the private individual land, my lord. And my clan. The clan also has
Or per descendant? What is the criteria? Let us go to the memo.
Yes, my lord. Nothing, my lord.
OM,
Yes, yes.
you're referring to 16? Which
At
page?
page number 41, my lord. May I read, my lord? It is also clarified that it is not the policy of the government to provide employment or other facilities to the landowner in perpetuity. The employment or other facilities of landowner, if permitted by a variable and valid agreement, is limited to the person first appointed as landowner in government service and does not entitle.
So your petition is maintainable?
Yes, my lord.
Okay.
Yes.
All right.
Lordship, just one last point. I've set for an interview, and if my lord were to peruse the mark sheet also, the interviewees, all 5 of them, they've given me more marks, and even going by merit, I have secured 37.5 marks, while the petitioner had secured 25, Lordship. So, coming back to my point that she has subjected herself to this selection.
27 is fail.
Lordship,
No.
but the candidate
Out of 50.
Yes, ma'am.
27 is out of 50.
Even on merits, I have secured more marks than the petitioner.
No, but you see, your ancestor had already over the same plot of land.
Yes.
Your ancestor was already appointed earlier.
Yes.
Yes. So it was the case of the state that.
So OM has to be respected, I think.
Yes. But the learned government.
The other landowners should be given opportunity also, my lord. The other landowners should be given opportunity. One family cannot be available time and again. There are 11 landowners here, my lord.
Learned government counsel is not here, but she had placed an argument before my lord that this could not be for perpetuity. It has to be exhausted at some point of time. Therefore, it was the case of the government that this has been exhausted, my lord.
What is exhausted?
The quota.
Yes, you have exhausted your quota.
Yes, my lord. The private respondent has exhausted.
Therefore, the petitioner could not have claimed that now. Lord, that was what was submitted earlier.
No, but you have the court's direction.
Yes, my lord.
Only the selection procedure was not challenged, according to you.
Yes, Lord, certainly. And since it is settled law to unsettle that, Lord, there may be miscarriage of justice if that were to be done.
So selection procedure resulted in the appointment.
Yes, Lord.
So appointment has to be can be cancelled.
Yes, my lord. Yes, it was not as per the procedure.
Where do you challenge the selection procedure? In what manner? You'll have to challenge the appointment.
Yes,
Then only you can challenge the selection.
My lord knows too well that the law is for the vigilant, not for those who blissfully slips over their rights, Lordship.
No.
Even in that judgment, the sole appointment order was challenged, Lordship, which was held to be as impermissible, Lordship. The judgment that I
Okay, I'll go through the judgments. Okay. I'll have to go through the judgments. Supreme Court's judgment also. And one judgment is similar to this case also. That WPC, not the GLT, the WPC. WPC. One is GLT of this court and one is WPC of this court.
Yes, Lord.
So the WPC is similar to this case.
Both of them are similar also on land ownership.
On land ownership, okay.
But my humble last submission that my lord may kindly take note of the point that in the present case there was a condition. And whether in those cases there were condition or not, that is also a question. In present case there was a strict condition that when 2019 should be followed. Yes.
I can never miss that. This
Yes,
is
my lord.
the case rests on that condition.
Yes, my lord.
So I'll not miss that.
Yes, my lord.
Heard learned counsel, Mr.
A. Sophie, my lord.
S.
A. Sophie.
A. Sophie for the petitioner, learned, learned senior government advocate, Mr.
Mua Imchan.
Mua Imchen for the respondent number 1, 2, 3, 4.
Yes, my lord.
And learned counsel, Mr. R.
ALEZ.
Okay. For the respondent number 5, reserved for judgment in order.
Right, my lord.
Okay, thank you. Over list, then there were 2 for argument, 2 for hearing. No, this is over. Okay, I could have dictated the judgment in your presence. Okay. No, but I won't hold you back. Pin this up.
You want the names? Huh? Do you want the names? There's one number of that's name in the context too. It's not. It'll teach it.
Tôi một với chỉ kít nó sao vậy này, là còn cái đơn được của tôi mới là gì nữa rồi, buồn lắm rồi.